Good morning, Chairperson Nadeau. My name is Zach Ragone, and I serve as the Policy Director for the National Reentry Network for Returning Citizens. We work directly with returning citizens navigating reentry in the district, not in theory, but in practice. We see where policy works, where it falters, and where well-intended protections fail to translate into measurable outcomes. The district has taken meaningful steps through the Fair Chance employment and housing legislation. These laws recognize a basic truth. Employment and housing stability are foundational to successful reentry and long-term public safety. Today's testimony is not about the intent of these laws. It is about whether the current enforcement structures ensures those protections function in practice. Recently, one of our clients applied for a position with a national retailer operating here in the district. He never received a conditional offer of employment. Instead, following a successful interview with the local office, he was contacted by corporate representative and asked detailed questions about the nature of his offense, including specifics about the circumstances and the victim. After a lengthy and uncomfortable conversation, he ended the call himself. Days later, he was informed he was not selected. He was generally aware of ban the box, but believed it simply meant criminal history could not appear on the application. He did not understand the timing requirements under district law. By the time he learned more about his rights, weeks had passed. He had no documentation of the conversation, no written confirmations of the background checks he was told occurred, and no realistic expectation that filing a complaint would restore the opportunity. He was navigating the time demands of supervision requirements, employment instability, and housing concerns. He ultimately chose not to pursue action. This case illustrates a pattern we see repeatedly. Whether the specific situation constitutes a legal violation is not the central point. The point is that enforcement of fair chance protections depends heavily on an individual's awareness, documentation, and capacity to pursue recourse, often while navigating the instability of reentry. The individual's experience reflects a broader data reality. Returning citizens are not disengaged from the labor market. Among formerly incarcerated individuals aged 25 to 44, labor force participation rates exceed those of similarly aged peers in the general population. They are actively seeking work. Yet research consistently shows that applicants with criminal records are over 50% less likely to receive a call back than identical applicants without records. The presence of a record cuts job offer likelihood roughly in half. Against this backdrop, OHR's FY24 report reflects 8 employment complaints under FCRSA and 2 housing complaints under FCRSHA. 8 and 2. That is not evidence of compliance or success. That's evidence of structural barriers to enforcement. The district's fair chance laws primarily regulate timing. They prohibit criminal history inquiries before a conditional offer and require certain procedural safeguards afterwards. Criminal history or returning citizen status, however, is not currently a protected characteristic under the District of Columbia's Human Rights Act. As a result, the framework regulates when criminal history may be considered, but not the breadth of exclusion once consideration is permitted. More importantly, enforcement is almost entirely complaint-driven. Several structural barriers limit the practical impact. First, awareness gaps persist on both sides. Many employers may not fully understand the district's specific requirements. At the same time, many returning citizens have only a vague understanding of ban the box. Second, transparency and documentation are limited. If an applicant does not receive a call back or is informally rejected prior to conditional offer, there's no documentation indicating whether criminal history was considered prematurely. And third, the incentive structure discourages enforcement. The current framework expects individuals navigating supervision, housing instability, and employment searches to pursue an intensive complaint process. If a civil rights structure only works for people who can navigate it perfectly under ideal considerations, it isn't meaningful protection. It's a procedural gesture. The district has an opportunity to decide whether fair chance policy should now prioritize strengthening transparency, accountability, and proportionality. It may want to consider ways to strengthen its fair chance legislation through measures such as establishing a right for applicants to request written affirmation that no criminal history inquiry occurred, providing proactive compliance review authority to OHR with respect to large employers and property managers, and expanding proactive outreach to major employers and property management entities in the district. Beyond strengthening the existing laws, the district should seriously consider whether returning citizens warrant broader protection under the DCHRA. Under the DCHRA, it would shift the legal analysis from whether procedure was followed to whether exclusion itself is justified. Employment and housing access are not abstract policy goals. They're central determinants of recidivism, public health outcomes, and long-term public safety. Oversight provides an opportunity to ensure that the commitment translates into measurable impact. We look forward to working with the Council and OHR, and we thank you for the opportunity to testify today.